This is Paul. Yeah, I had a little while these were loading up, so I thought I'd just look at something here. I'm reading You and the Law. Yeah. It says here the facts particular driving unless he was such facts are determined in a trial, sometimes by a jury, sometimes by a judge without a jury. The judge then applies the law to the facts as the jury finds them. Then you have what's called the appellate court. Yes. And at least in theory, does not review the finding of fact. It only functions to decide whether the trial judge correctly applied the law. Believes he did, his decision upheld, but if finds the trial judge did make a mistake applying the law of the facts or in procedure, it will reverse and modify the decision. And then if the subject matter of the lawsuit in the state court involves a right under the United States Constitution, if, for example, the plaintiff charges under the state statute has probably been taken without full court review, violating the constitutional right to due process of the law, and the highest state court decides the Constitution is not violated, an appeal may be taken to the U.S. Supreme Court. The court always has the last word on matters involving U.S. Constitution. The United States Supreme Court has the last word on the matters of the U.S. Constitution. Yeah. I got to thinking about it. There was the facts and findings of the dissolution of marriage. Now, I know I responded to the dissolution that was served on me when I was arrested for violating a protection order where there was no jurisdiction. Yes. And I wondered why Judge Rohrer would allow for a dissolution of marriage where the male was unclaimed and where there was no actual proof of service. Now, as I understand getting divorced, you actually have to have jurisdiction over the subject matter, the United Nations marriage certificate. You'd have to have my response, all 50 pages, plus the 5 written pages explaining that I didn't want a divorce. You'd have all the handwritten information that the plaintiff provided, but there was no documentation that I had seen. In fact, it seemed like documentation was almost anathema to those that are in the fish family of judiciaries. Yeah, I document everything. Now, there are some that say, well, you could motion the court and you could appeal the divorce, but I was never served any finalized divorce documentation. I never got the final divorce. I never got anything from the state of Washington about child support. I never got anything! That was that $1.86 that was taken from me when I went to jail on January 4th. Yeah. Got out of jail after seeing the magistrate. Poo-poo. I would have thought that there are laws that require that a person be allowed to have a minimum amount of assets. Taking $1.86 violated state law, didn't it? Yeah. Being homeless, having put it on the violation that the guy was homeless, and then I put on the magistrate form when I went to the court hearing, yes, homeless. Now, I know the state of Washington thinks that they can take anything and everything that a person owns, but taking that $1.86 and then serving me with an $81,000 back child support bill when I've never been served the actual dissolution of marriage, and I was never served any order for child support or anything else. It could be a great amount of abuse of power. Now, I know appellate courts, does not review the findings of fact. But there must be a certain amount of time that an ex-wife has to take her name off of a bank account. Would have had to return my stolen property. would have had to serve me the actual finalized dissolution of marriage, would have had to serve me some sort of court order from the state to have to pay child support. I'm just going to want my rights today.